we're going to start on page 22. Okay, so tonight we are going to talk about this court systems that we have here in the United States. And we'll talk a little bit about how a lawsuit works in the civil court system, not criminal but civil. So both the federal and the state courts. We're going to get into the various different courts that we have. So I just want to kind of start by giving you a little bit of an idea of what I'm talking about. So one of the things that, as an attorney, I have to do, if I'm going to file a lawsuit on behalf of my client, is I have to pick the correct court where the lawsuit's going to be filed. And vice versa, if I have a client that's been sued in civil court or charged with a crime, I have to make sure that it's the correct court. Because if it's not, then I need to have the judge dismiss the case because the court doesn't have authority to handle the case. So I got to pick which court to file the case, right? And this seems so simple, but let me show you the idea of what I'm talking about. All right, so this is a map. Now remember, we're a federal system, so we have federal law. We also have federal courts. We have state law. We also have state courts. So every state's going to have its own court system. So this is a map of the federal court system, and I'll go through this in more detail in a little bit. But I just want to give you an idea. If I'm going to file a lawsuit, I've got to figure out which court to file it in. And I'll give you a real specific example here in a few minutes. So in terms of the federal courts, the question is, how many courts are there? Well, in each state, there's at least one federal court district. Some states have up to 4 districts, like California, because of their population. So we have 50 states. You total those all up, and there's about 94, if I remember, federal court, what we call district courts. Not very many. And then we call those trial courts, and I'll explain that more in a minute. From there, we have what we call an appellate court, which is a higher level court that will review the lower court. And we have 13 of those. Then we have the U.S. Supreme Court. So we have about, what's that, 94 and 10, about 108 to 110 federal courts. Not that many, right? That's not the problem. Here's the problem. Look at this map. A little different. Do you know what this is broken down by? Any guesses? This is the United States broken down by county. So how many of them are there? You guys count them up real fast, will you? Any guesses? About 3,000, right? Yeah, you were going to say 3,124, right? Yeah, that's what I figured. So about 3,000 counties, okay? Now, within each county, you're pretty much on average going to have at least one, if not more, court systems. It's like here in Polk County, where we're located, right here, we have 4 court systems. We have Monmouth Municipal Court, Independence Municipal Court, Dallas has a city court, a municipal court, and then there's a circuit court for the state of Oregon, which is located in Dallas, called the Polk County Circuit Court. So we have 4. So you got to choose which is the right court to file the case, or if you're representing somebody that's been charged with a crime or accused, you got to make sure it's in the right court. So if each of these counties have at least one court, that's 3,000. 2, 6,000, on average 3, or up to 9,000. And so you can just get an idea, especially on the eastern side of the United States, where the counties are really small compared to what we have here. There are a lot of courts. And I got to pick the right court to file the lawsuit, because if I don't, then a judge is going to throw it out. And if it's beyond a statute of limitations, I may get sued for malpractice because I filed the wrong case. So I've got to figure out where to file the lawsuit out of all those possibilities. Now, usually it's pretty straightforward, as I'll show you here in a minute, but sometimes it's not quite as simple as just saying, okay, that's where the accident happened, we'll file there. So that leads us to page 20 and 21. Jurisdiction. And that's where we're going to start tonight, is jurisdiction. So first of all, 100%. for sure, on the midterm, this will be a fill-in-the-blank question. List up to 6 types of jurisdiction. Usually I only ask for 4, but sometimes up to 6. There are 10 types of jurisdiction that we're going to talk about. So out of those 10, I want you to be able to list up to 6 of them. And we'll go through them all so you know what they mean. So first of all, just in general, what do we mean by jurisdiction? Last week we talked about jurisprudence. This week, jurisdiction. There's that word juris again. So juris is law. Diction, basically to speak the law. It's kind of a plain English way of saying it. But really, more so it means the authority of a court to handle a particular type of case. The authority of a judge to issue a legally binding decision. The authority of a court, basically. So in order for a judge to handle a lawsuit, either criminal or civil, the judge has to have jurisdiction. If not, it's the wrong court, and the judge has to dismiss the case, throw it out, basically. All right? This also is how we go through and figure out which court we file in. So I'm going to say on average, there's about 10,000 courts around the United States. Now that's just courts. There may be, within one court system, 100 different judges in Multnomah County. And so, across the United States, there may be 100,000 actual courtrooms, maybe more than that, I don't know. I tried to count up before and I never could figure out an answer. So, we've got to break down all these thousands of courtrooms into manageable bites so we know where to file our case. So the first place we're going to start are the 2 basic broad types of courts. Trial courts and appellate courts. All courts are going to be broken down into one of those 2 basic types. A trial court or an appellate court. And just in general, a trial court is where the first place a case is going to be initiated. That's where you're going to start a lawsuit, or if it's a criminal case, that's where the criminal charges will first be charged against the defendant, the criminally accused, in a trial court. And then you'll have a trial, we'll get into that more in a minute. Then we have appellate courts. Appellate courts there's far fewer of them than trial courts. And basically the job of an appellate court is to review what happened at the trial court, or for a higher level appellate court like the U.S. Supreme Court, to review what happened at the lower level appellate court to make sure that the decisions were made by the judge correctly. So it's kind of like in football, right? Or any sport for that matter, but Super Bowl's coming up, so we'll use football. So the game itself would be the trial. What the players did, what the result of the play was, and then the official's decision, or better to call a pass interference for that matter, right? Yeah. So, long story short, the decision by the referee or the umpire or whatever sport you're talking about on the field, the ruling on the field, would be like the trial court judge making a decision during the trial. And then when it goes up on video replay, that's going to be like the first level of appeal. And then from there, it may go to the commissioner or some higher level group, and they may review what the officials did and take further action after the game, and that would be like a Supreme Court. So that's kind of the basic comparison. So we have trial courts and we have appellate courts. There are far more trial courts than there are appellate courts. Literally, maybe 10,000 trial courts around the United States versus about 120 appellate courts. So like 10,000 to 100 ratio. So there are far more trial courts. All right, so a couple things I want you to know about a trial court. And I will tell you right now, I have several test questions that come off of this little page right here. The first thing I want you to know about a trial court is a court of what we call original jurisdiction. Original jurisdiction. That basically means that is where a case must begin. You must start in a court of original jurisdiction. It must originate in a trial court. Now, there are some exceptions to that, which we won't get into in this class. It gets way technical. But what I want you to know at this level is a trial court is a court where you got to start the case. Simple as that. In other words, I'm not going to file my lawsuit in an appellate court to begin with, because they don't have original jurisdiction. You've got to file it in a trial court. So that's the first thing I want you to know about trial courts. So on the test, if I ask you, okay, which of the following courts is a court where I need to file a lawsuit to start? The answer, a trial court. Okay? Simple. Part 2, a trial court is a court where you're going to have your trial. That's what we call a trial court. Well, what's a trial? A trial is where two types of issues or questions are going to be determined, proven, argued about, and then a decision made. Factual questions and legal questions, or questions of law. Questions of fact and questions of law. So factual questions are who, what, where, why, and when, right? Who is identity, what was the weapon that was used, where did it happen, who was the perpetrator, why did they do it, motive, intent, all those kind of things, right? Now, you guys remember the example I gave you, I think it was last week, of the belt buckle case, right? Guy hit the other guy in the face with a belt buckle. The question was, is that a weapon? Well, that case was all dependent upon the facts. In that case, the guy who hit the other guy, because he was drunk, he said he fell over. In which case it wasn't intentional. In which case it wasn't a weapon. On the other hand, if he did it on purpose, he whacked the guy on purpose, then it would be a weapon because it was done intentionally. So there's a difference in facts. There's a dispute about what happened. That's what I mean by a question of fact. What happened? Now you're going to have two sides to every story, right? So the jury and the judge are going to have to decide in a trial what actually happened, who do we believe, what does the evidence prove. So here's the other thing I want you to know about a trial court. A trial court is where evidence comes into the record to prove the facts of the case. Evidence can only come in a trial court. You're not going to be putting new evidence on, having witnesses or anything like that in an appellate court. Kind of like in football again, the play is on the field, but with the players, they don't replay the play over again. So in court, we're not going to have a whole new trial. The evidence that is presented and accepted by the judge, we call that putting it into the record, in the trial, then goes up, a record of that is then sent up on appeal. So you're not going to have new witnesses or other kinds of evidence, all right? So evidence can only be in a trial court. Now what do I mean by evidence, okay? Who, what, where, why, and when. Evidence is what you use to prove the facts. So who, that's identity. How do I prove somebody's identity? What are some ways, what kind of evidence can I use to prove identity? Any ideas? What do I have in the end of my fingers? Fingerprints, right? That's one way. Best way? No, not always. What's another way to prove somebody who they are? What's the best way? Witness identification, is that the best way? Hey, I know that person, right? It's one way to prove, it's not absolute proof. What's the best way? How do I prove it's somebody? 23andMe, right? What's that? DNA. DNA is, the strongest evidence of identity. So there's lots of different kinds of evidence. So when I talk about evidence, what I'm talking about is medical tests, blood tests, DNA, tax returns, bank records, videotapes, photographs, police reports, medical records, dental records, accounting records like QuickBooks, banks, I just said bank statements, tax returns, you get the idea, right? That's evidence. Witnesses, they come in to testify at a trial, and they say what they saw, That's evidence, witness testimony. So all of that has to go into the record in a trial court. It's one of the jobs of a trial court judge to decide whether the evidence is valid or not. Was the DNA test properly performed? Was the evidence collected by the police officer correctly? Was the blood test properly drawn? Was the photograph manipulated by Photoshop? That's part of the job of a judge to determine if the evidence is credible and valid, to be allowed to go on the record. All right, so long story short, no new evidence on appeal. Evidence is only put into the record in a trial court. All right, so those are factual issues. Next we have legal issues. These are what we call questions of law. So a question of law is things, are issues that are, like for example, whether or not a law is constitutional, whether or not a higher law preempts a lower law, like we talked about last week, whether or not a police officer needed a search warrant to search somebody's storage unit, or if there was some other reason they did not need a search warrant. That's a question of law under the Fourth and Fifth Amendments, right? And so the idea of question of law is a judge will have to decide, did the police act properly? Was proper notice given by the landlord when they tried to evict somebody? All those kind of things. Is it constitutional? So those are questions of law, and that also has to be raised during the trial. It's called making a record. Otherwise, you can't argue it later on in an appellate court for the most part. All right, so trial court jurisdiction, original jurisdiction. Those are the first two types of jurisdiction. Now, appellate court. I'm not going to spend a lot of time on appellate courts, but basically the basic job of an appellate court is to review the decision by the trial court or a lower appellate court to make sure the judge at that level made the correct decisions. And again, just like in football or baseball or basketball, whatever, where you've got video replay, make sure that the officials made the correct decision. They're not going to go have a whole new trial. The evidence will be brought from the trial court up to the appellate court. So everything that the witnesses testified to, they'll have a transcript, all the photographs and videos and all that will be transferred up, and then they'll review it at the appellate court level. So no new evidence. Now, with that said, just so you know, sometimes you'll have a situation where after a trial, no new evidence is discovered that would have materially changed the outcome of the first trial. Like back in the 80s, when DNA was really starting to come into play, we had a lot of DNA cases where it proved the person that was convicted maybe wasn't guilty. And so you can ask for a new trial after the fact when new evidence is discovered, but that trial won't be held at the appellate court. It'll be sent back to a trial court. Okay? I won't really get into that in this class. If you know this much, no evidence on appeal, you're good. All right? And the basic jobs. Okay, so three types of jurisdiction. Trial court, original, appellate court jurisdiction. Yeah.
You said there's a lot more trial courts than our appellate courts.
Yeah.
I mean, if you guess or whatever, what would be the percentage of trial cases get thrown up to the appellate court?
1%? Maybe. I don't know. I'm sure there's been studies done.
They're very small.
Very small. Yeah, very small. For lots of reasons. Number one, it's expensive. Number two, you're just flat out guilty or wrong. There's no reason to appeal. But yeah, of like all criminal convictions and all civil cases, very few get appealed. Very few. Yeah. I don't know. It'd be kind of interesting to look that up, but I would say about 1%. Or, that might be a little low, but I don't know. It's not very big. Yeah. Did you have a question back there somewhere? No? Okay. All right, the next two types of jurisdiction. Exclusive and concurrent. Now remember what we're trying to do. We're trying to find which court in all of the United States has authority to handle a case. So sometimes only one court has authority to deal with a case. And we call that exclusive jurisdiction. Only one. Other times, more more than one court will have jurisdiction. That is what we call concurrent. Exclusive, only one. Concurrent, more than one. That's really all you need to know for this class. And then I'll give you an example later to show you what I mean. So for example, exclusive would be bankruptcy court. Bankruptcy court is bankruptcies. If you can't pay your debt, you can ask to file bankruptcy and have your debt either totally wiped out or put on some kind of a payment plan, depending on the type of bankruptcy. Bankruptcy can only be filed in a bankruptcy court where you live. You can't file it in a different kind of court or a different place. It has to be where you live in a federal bankruptcy court. So that's the only court that can handle that. Concurrent, more than one court. And I'll give you an example out here in a few minutes. Like state court and federal court may have jurisdiction at the same time. That's concurrent. I guess another example would be like, let's say somebody stole a car in West Salem and drove over the bridge to downtown Salem. Polk County on one side of the river, Marion County on the other side. So you'd have two counties that could handle that case. And then usually they'll figure out which one wants to do it. All right, so that's 5. Trial court jurisdiction, original jurisdiction, appellate court jurisdiction, exclusive jurisdiction, concurrent jurisdiction. Okay? And we're going to have 10 of them. So next page for the next 5. So page 21. Again, I want you to kind of remember what we're doing here. We're trying to figure out of all these thousands of courts, which court is the correct court. So I have a little equation. P plus S equals J. Now this is a math class, don't worry, you don't have to do math. P is personal jurisdiction. S is subject matter jurisdiction. So in order for a judge to have authority to handle a case, you've got to have both. Personal jurisdiction and subject matter jurisdiction. Now in plain English, what are we talking about? Location, where, and what type of case is the lawsuit all about? Where and what type? Where and what, right? Where and what? So the first one's geographical, and the second one is what kind of case are we talking about? Subject matter. So personal jurisdiction, let's start with that one. This is the idea that in order for a judge, let's say here in Polk County, in Dallas, to handle a case, the plaintiff, the party that filed the lawsuit, and the defendant must have some connection with the physical location where the lawsuit was filed. So if I file a lawsuit over in Dallas, in the Polk County Circuit Court, both the plaintiff, my client, and the defendant, whoever I'm suing, must have a connection with Dallas, Oregon, or Polk County at least, not necessarily Dallas, anywhere in Polk County. Now what do I mean by a connection? Well, you live there. That's a connection. You're a resident of Polk County. You go to school there. Maybe you're not a full-time resident, but you go to school at Western. That's a connection. Maybe you own a business in that location. That's a connection. You're doing business there. You do sales in that location. You sell products. You have a storefront, a manufacturing facility. You own property there, like a house or an apartment. Or maybe it's something different like a shipping issue where you have a ship in port or an aircraft or a pile of gold or whatever, a bank account. So those are connections. And then the final one, which I think is the most important, is where did the event that led to the lawsuit or criminal case take place? That's the first place you should always start. Where is the event that led to the case? So let me give you an example of what I'm talking about here. Back to my map. You don't really need to change your page. Just look up here for a minute. So I live in Oregon, right? So let's say that I am going to drive to the Grand Canyon down here in Arizona. So I'm in my car, and I'm driving down the Grand Canyon, and I get into a car crash in Nevada on my way to Arizona. The person that's driving the other car, they ran into me, it's their fault. Let's say they're from Utah, they live in Utah. The car crash happened in Laughlin, Nevada, right there. So I live in Oregon, they live in Utah, we got into a car crash in Nevada. So let's say I file a lawsuit against them in Oregon. What does Oregon have to do with it? Nothing, right? So it's the wrong place. There's no personal jurisdiction. The Utah person isn't from Oregon, so there's no, the Oregon court doesn't really have anything to do with the case. So Utah, I could file there, but the same problem now is I don't really have anything to do with Utah. They live there. But where do we both have a connection? We both have a connection where the automobile accident occurred in Laughlin, Nevada. And so that's where I would file the lawsuit. I don't know what county that is, but down in Laughlin, Nevada, because that's where the event occurred. There's a connection with both of us. Now sometimes you may have a connection with multiple places. So like for example, let's say that I have a client that got an operation on their hip, had a hip replacement. And the metal that they used for the hip implant starts to degrade, so it's faulty. So that's going to probably end up being a class action lawsuit, lots of different people. So I'm suing a huge manufacturer, maybe it's a drug case, or I'm suing Pfizer Pharmaceuticals or whatever, or maybe I'm suing Microsoft. Where does Microsoft do business? Everywhere, right? So basically, yeah, everywhere would be a connection with the court because they basically do business everywhere. And that goes back to that concurrent thing I was talking about earlier. So long story short, here's what I want you guys to first of all think of, okay? Where do I file the lawsuit? Where in the map is there a court that both sides have a connection to? Now usually it's going to be, where did the event happen? The automobile accident? Where was the contract signed? Where did the sale take place in a business transaction? Where was the surgery performed? Where was the fire that led to the loss? Whatever, okay? So look for an event as the first place. You're like, well, why don't you just always file where the event took place? Well, I'll get to that in a minute. I'll give you an example. I'll show you why in just a minute, okay? Sometimes you don't want to for strategy purposes. All right. So first thing you're going to do is look for location. Location, location, location. We're going to look for where on the map does a court have connection with both parties. Number two, then we have to determine what kind of lawsuit is it? What is the law for which forms the basis of the case? What kind of case is it in plain English? So back to bankruptcy. If it's bankruptcy, I'm going to file bankruptcy court where the person lives. Personal jurisdiction would be where they live. What type of case is it? Bankruptcy. Yeah?
What is personam or whatever?
Oh, in personam.
Yeah, in persona.
Yeah, it means the same thing. It's,
Oh, okay.
yeah, sometimes it's referred to that. Sometimes it's spelled with a U.
I thought
here.
I was stupid for that.
Yeah, don't worry about it. If you just know personal, you're good.
Yeah,
There's an alternate way of saying that.
got you.
Yeah.
And
We're
would
going to
there
have a lot of,
And would there be questions on the test like cases where we break down to see stuff like that?
you're a step ahead of me. Exactly. What I'll do is I'll say, okay, Bill and Ted got into a car crash in Iowa.
Good.
And Bill lives in Utah and Ted lives in New York. And the value of the case was, $1 million. Which courts could have jurisdiction? And then I'll give you like a multiple choice.
Gotcha.
Yeah,
Okay.
you're thinking the right thought right there. It's exactly what I'm leading up to. Okay, so subject matter, what kind of case is it? All right, we got to pick the right court. So in rem, let's talk about that. For you guys, you don't really need to worry about this one too much. In rem basically means a court will have jurisdiction because you own property where the court's located. So this is usually used in either aviation or maritime law, shipping, or an airplane. So like, let's say I own a ship, like I'm a big shipping company, and my ship, there's a big storm and my ship goes into port and crashes and sinks, and now there's a bunch of environmental damage. And so normally my ship doesn't go to that location, but because my ship is located there, the court where it was located would have jurisdiction. It's like, yeah, it's like the new Carissa, you guys remember that down in, is it Coos Bay?
Yeah.
Yeah. That was, it was on the, nobody knew who had authority over it. It sat there for a couple years. But for you guys, don't worry about it, okay? It's simple enough. You own property there, the court has jurisdiction over the property. Simple enough. All right, now it's going to get more complex. Remember, we have federal and state. So now the question is, federal court. If you want to go to federal court, it's harder to get in. And to begin with, there are far more state courts than there are federal courts. So like those maps I showed you earlier, this is the map of the federal system. Basically, there are 94 trial courts, 13 appellate courts, and 1 U.S. Supreme Court. Not very many. Versus this map, this would be the state courts. So literally about 10,000 to 100 ratio of trial courts. And the reason why is most court cases, civil or criminal, are based upon a violation of state law, not federal law. Most cases are going to be based on state law. So just to kind of give you an example of what I'm talking about, what do you suppose is the most common type of event where people that don't know each other or have any relationship with each other whatsoever before the event might sue each other? What kind of thing would happen?
Can you elaborate on that?
So people that don't know each other whatsoever, all of a sudden something happens and one of them sues the other one.
Maybe copyrights?
Copyright could be, but I like the most common.
Shipping.
Could be shipping. Car accident, exactly. Yeah, but you guys are right too, but I mean most, like the most common. I don't know you, you don't know me, you run into me. So I sue you because I'm hurt. So that's probably one of the most common reasons people sue each other. That will typically, sorry, back to page 21. Okay, so most of the time, an automobile accident will, the reason for that will be a violation of a state law. Like in Oregon, if you go through a stop sign and you don't stop and you run into me, that's Oregon statutes, ORS 811 something. Federally yield to a traffic control offense. So that's a state law. What's another common reason people might sue each other? Like most common? Money. In other words, you didn't pay me money you owed me, like Visa or whatever. A loan, right? Breach of contract. That's based on state law. Another reason that people might go to court against each other that's really, really common, actually probably the most common. Dissolution of marriage, divorce.
I was just going to say that.
Yeah, exactly. So those are like the three big ones, right? Divorce, car crash, breach of contract. Guess what? State law controls the divorce case. So where I'm leading up to, the reason why we have so many more state courts is because we have more state law, and most cases are based upon a violation of a state law or involve a state law as opposed to federal law, right? So, federal court, in order to get into federal court, you must have a case that involves one of these two types of jurisdiction. If not, a federal judge is going to throw the case out and send it to state court. It's called a removal to state court. Federal judges don't want to deal with cases if they don't have to, nor legally can they. They don't have authority. So I guarantee you, I will test you on these. I want you to know both of these. And like the example that you brought up, I'll say, okay, does this, the federal court apply here or not?
Okay.
And you're gonna want to memorize this, including the dollar amount. Usually I don't care if you know a dollar amount, this time I do. I want you to know the dollar amount. All right, so I'm gonna start with letter B. So one way to get to federal court is if the lawsuit involves a federal law, either criminal or civil. Federal court every time, if you want to go to federal court, federal law, we call that federal question jurisdiction. Violation of federal law or the lawsuit's based on a federal law. If that is the case, then there's no dollar minimum, $0, doesn't matter. Doesn't matter where the people in the lawsuit reside. They can live in the same state. If it's a violation of federal law that's being alleged, then you can go to federal court every time. So what do I mean by that? All right, well, maybe I'm suing a logging company to prohibit them from cutting down trees because it's going to interfere with endangered species habitat. That's the Endangered Species Act, federal law. So I go to federal court and ask a judge to prohibit the logging. It's called an injunction. Or maybe it's a Title IX discrimination case, that's federal law. Or Clean Water Act, Clean Air Act, any kind of federal statutory basis, U.S. Constitution, equal protection, all that stuff, right? So that would be federal law, yeah.
All right, like, okay, cases about federal, and again, we'll just go back to like the whole federal government being over the state government.
Right.
Even though a state might have, similar types of.
Yeah, so basically what I'm saying here is if I go to if I want to file a federal lawsuit, one of the first things the federal judge is going to look at in the lawsuit is, okay, what is the law that this lawsuit is based upon? And I got to put it right there in my pleadings. We'll get to pleadings here in a little bit. But the idea is I got to show the judge, okay, judge, I'm alleging a violation of the following federal laws. Title IX of the United States Code, Section 1983. Title 14, U.S. Code, Section 2302. Whatever, I got to list them all out.
But the federal law would have just like the supremacy of the state law.
Right.
Right. Okay.
Yeah. And that sometimes, that might be the issue. Does the federal law trump the state law or preempt the state law? And that would be, you're asking a federal judge to decide that. Yeah, absolutely.
But do they even use the laws though, in some cases? Or do you just think it's off of how they feel? Because I don't feel like everybody uses the same laws that you're supposed to use.
Oh, that's a great question. And I would tend to agree with you.
Yeah.
Part of it depends on like a judge's viewpoint on things. Because, like some judges may say, well, this law doesn't really apply anymore because it's too old or something like that. Yeah, and that's a very real thing, very real, yeah. And that's part of the reason why we have appellate courts too. So like if a judge down here makes a totally goofball decision, it can be overturned on appeal. Yeah. All right. Okay, so that's federal question. So long story short, federal law, federal court. Simple, right? This is where it gets more complicated. If the lawsuit is not based upon violation of the federal law, then you've got to meet the requirements for what's called federal diversity jurisdiction. Now, when we use the term diversity here, we're talking about people that do not live in the same state. They live in two different states. If they live in the same state and the lawsuit involves a state law, you cannot sue in federal court. That's considered a state court matter only. In addition, so right here, okay, you gotta have both. In addition, the case must have a value of more than $75,000. Judges don't want to deal, federal judges don't want to deal with small cases. That amount will probably go up someday. I've heard talk of maybe $250,000 as a minimum, or maybe even $1 million. Probably won't be $1 million, but because they've been talking about that a long time. So. But I want you to know those two requirements, okay? Got to live in two different states, and the value of the lawsuit has to exceed $75,000. So $75,001, right? Got to be more than $75,000. If you don't meet both of those requirements, you've got to go to state court. You cannot go to federal court on a state law case. Now, partly the reason why for that, just so you know,